Good morning, everyone.
Good morning.
Good morning.
Good morning.
Your case is taken down. Please chat me and I'll have your information. Good morning, Monica.
Good morning. How are you?
I'm well. How are you?
I'm doing great. Thank you. Good morning, Council.
Morning, everyone.
Good morning.
Good morning, Your Honor.
All right, we're here for our motions and non-jury calendar. So the way I'd like to proceed this morning, we've got a number of cases involving the National Collegiate Student Loan Trust. I'd like to take those on first. And
Good morning, Your Honor. Sharice Taddy here for plaintiff on those matters.
all right, very good, Ms. Tadde. And then we've got a couple of, I think, maybe a little bit more involved hearings. Central Mutual Insurance Company versus Sims.
Silas Harrington on behalf of Central, Your Honor.
All right, so we've got a hearing on damages, which I plan to take after I do the National Collegiate Student Loan cases.
Yes, Your Honor, and I anticipate that would take about 3 to 4 minutes.
All right, and then I may get you out. I may get you out first, Mr. Harrington, since I've got a number of these on National Collegiate Student Loan Trust. So we'll
However you would like to do it, Your Honor.
we'll get you out early. Then I've got 2015-1 IH2 Borrower LP versus Nicole Harris.
Morning, Your Honor.
Good morning.
Your Honor, I represent plaintiff in that case. I think it depends on whether the defendant appears, but if the defendant doesn't appear, then I'll think it'll take 5 to 10 minutes.
I'm here.
Oh, okay. Then I anticipate it'll take 25 to 30 minutes.
All right, Ms. Harris, do you have counsel?
No, I don't.
All right, you're representing yourself today. Very good. All right, so so Ms. Harris, you can put yourself on mute. It may be about 20 or 30 minutes before we get to your case, but we'll
I wanted to. Oh yes, I wanted to let you know I'm out of power. We have a power outage, and I don't know how long I will be able to last on here. Is there any
All
way?
right. So why don't you do this to preserve power? Why don't you go ahead and step off the Zoom until 10:30, then jump
Okay.
back on at 10:30, and hopefully we'll be ready to take you then. All right.
Okay, thank you.
And Mr. Farrell, if you want to step, you're welcome to stay on, but if you want to step off until 10:30, you can do that as well.
Yeah, sure, and I'll do that. Thank you.
All right. I want 10:30. All right, why don't we go ahead then, so we can get you on your way. Let's go ahead with Central Mutual Insurance Company versus Sims.
Whenever you're ready, Your Honor.
I am ready.
Excuse me, John, is there a takedown on this case?
No, ma'am, we do not need takedown.
Thank you.
Your Honor, I have my one damaged witness, Lisa Jennings. Miss Jennings, could you please hold up your right hand so I can swear you in? Miss Jennings, do you swear or affirm that the testimony you're about to provide for this court shall be the truth, the whole truth, none but the truth, so help you God?
I do.
Okay. Miss Jennings, could you please state your full name for the court?
My name is Lisa Jennings.
Okay, and let me back up one moment. We are here today because the defendant in this case, while towing a trailer, lost control of his trailer, and that trailer slammed into the facade of Central's Insured's building, correct?
Yes, that is correct.
So, Your Honor, this is one of these slightly odd subrogation. It's not an automobile field subrogation action. It is a car hit building case. But could you please state with whom you're employed, Ms. Jennings?
Central Mutual Insurance.
In what capacity?
I am the Senior Claims Recovery Specialist,
And how long have you been in that business?
21 years.
Okay, by virtue of your training and experience, are you familiar with the fair market value of real estate and personal property?
Yes, I am.
Are you also familiar with the reasonable cost of repair necessary to restore buildings to their original condition before casualty?
Yes, I am.
And again, we are here today because the defendant, while driving, lost control of his trailer, and that trailer then slammed into the front of the building that Central Mutual Insurance insured, correct?
Yes, that is correct.
And where was the location of that building?
The location was at 2599 Church Street in East Point, Georgia.
Okay, and what was the fair market value of that building prior to the damage?
The fair market value was $178,500.
Okay, and was this property a total loss?
No, it was not.
So the facade of the building was repaired?
Yes, it was.
Okay, and what was the total cost of repairs to return the building facade to the original condition before the casualty?
The total cost was $41,547.31.
Was there any mitigation required?
There was not.
And were there any other, did Central incur any other cost in the repair of this building other than just repair?
Just repair, correct.
Right, and so the total damages incurred by Central in this case are $41,500.
$47.31.
Okay,
You want to repeat the total amount?
yeah, if you could
Sorry.
please repeat the total amount.
Sure. The total amount is $41,547.31.
Thank you, Ms. Jennings. And Your Honor, we would ask for a judgment in that amount against the defendant. And I have a proposed order I can provide to your office.
All right, go ahead and send that proposed judgment to Mr. Townsend, and that will be entered.
Thank you very much, Your Honor. May we be excused?
You may be excused.
Thank you,
Mr.
Your Honor.
Harrington.
You have a good day.
Thank you.
Thank you, Ms. Jennings. All right, let's talk about the National Collegiate Student Loan Trust cases. We'll go through them individually, but I did want to, we have Ms. Oh, she dropped off. Ms. Today dropped off.
Judge, I represent the defendants on 3 of those cases.
I'm sorry. I'm
We
sorry,
lost
Your
you
Honor.
for-
Sharice
We lost you
Taddy.
for a second.
Yeah, I don't know what happened. I got lost.
Just as we got to your case.
Of course, it wouldn't have happened any other time. Would have made no sense.
All right, so a little bit of history, I think, might be in order on these cases.
Certainly, Your Honor.
Back in 2017, the then chief judge entered an order staying these cases based on a consent order that had been entered involving National Collegiate Student Loan Trust, many of them in a federal case. since that time, there have been a number of cases that have popped up on the calendar. Eventually, when I did ask counsel to brief the issue of whether the stay applied to any of the cases before me, that brief was provided, filed back in late 2019. I've reviewed it. I'm satisfied that none of the cases that appear on this calendar today are subject to any stay or fall within the provisions of the order. So I think the parties are prepared to proceed, and I am prepared to proceed on all of them.
Okay,
Now, I think there are a couple of these where there was a motion for continuance. I guess those are the ones where you're representing the defendants, Mr. Armour.
Yes, Judge. Those would be positions 1, 8, and 9.
All right. You represent the defendants in all three of those cases.
Correct, Your Honor.
All right, so it sounds like, so how long ago were you retained in these cases, Mr. Armour?
Well, in position number 1, Jamie Pitts, I was trying to enter my entry of appearance with file and serve this morning and was stuck on the hold with the help line with file and serve. And so I don't think that's gone through yet. Positions 8 and 9, I believe my answers and entry are reflected on the docket. Position 1, Jamie Pitts, we reached a settlement in that just within the past couple of days. So we would request that we be given probably 30 days would probably be fine for us to get the settlement signed and dismissal to be filed. Is that okay with you, Sharice?
it is.
And
All
then
right. We'll continue that one.
position 8 is Nathaniel Williams. There is another case between the parties on that, and we're trying to reach a global settlement that will knock out both of those cases, and we're extremely close on that. So we anticipate that should get wrapped up in the next couple of weeks as well. Would you agree with that, Sharice?
I do, Chris.
And then position 9, the Michael Rodriguez, we have settled that one and anticipate that dismissal will be forthcoming in that one within the next 30 days or so as well, Judge.
All right.
That's correct, Your Honor.
All right, so all of those will be reset, and hopefully before it pops up on the next calendar, all of those will be resolved. All right. I think that concludes your business, Mr. Armour. So
Yes, may I be excused, Judge?
you may be excused.
Thank you, Judge.
Chris?
All right, so let's talk about the others. I think, well, let's go one by one. Let's talk
Yeah,
about
Your Honor, if
position-
I may suggest, can we start with the Brittany Woods versus Sarah Sanders, which is 18 EVOO 2066? That's actually the only matter, Your Honor, that I had a formal order that was issued in. And when I mean that, I mean that we responded to. I believe that is the one that you were referring to before, that you said respond on one and all. But as far as that one, it does have a proposed order attached to that, because we did file a response in that matter as far as lifting the stay. So I just wanted to let you know that the rest of them we're going to go through. They're not necessarily going to have the proposed orders, but I'll be happy to provide them to you as we go through them.
All right, so that one, number 4, we'll sign the order.
And Your Honor, I
believe there
don't
was an
believe
answer
on that
filed
one.
in that one. There was an answer filed in that one, but it was not a sufficient answer to raise a valid defense, so.
Correct. And there were also some requests for admissions that were never done back in the day, but we can surely get a default motion for default filed rather timely on that one, so that the court can possibly enter an order even without another hearing necessary, or if so, we can appear to later docket for damages.
All right, if you can do an affidavit on damages, then we won't need another hearing.
Excellent. I'll note that, Your Honor.
All right.
We'll get that filed in short order.
All right. Takes care of that one. So I think position 2 involving John Ross. Again, we're going to lift the stay on that one. I don't think it's ready in terms of entering a judgment. I didn't see an affidavit with that one.
Your Honor, I have received an affidavit since the time that we filed the motion for default, which was back in 2018. So we will submit that affidavit that you can then look in addition to that motion for default on the Ross matter. We'll get that filed ASAP.
All right, send with the affidavit, send a proposed judgment.
Yes, Your Honor.
And we'll be good to go on that one. Position 3, Lundstedt, I see that there's an answer in the docket, and that's sort of where everything stopped.
There is an answer in this matter, Your Honor. On this one, we actually filed a motion for summary back in the day on this. And then from the time that we filed the motion for summary and today, we resolved another matter on this particular defendant with the court. And the court issued an order granting us judgment in that matter that had very similar procedural posture as this case. In November 12th of 2019, we filed a notice of supplemental authority to accompany our motion for summary. And so it's based on that we would ask that judgment be granted. I believe on this one, Your Honor, we did already attach an affidavit. Let me be sure, but I think this one had an affidavit already. It does. This one already had an affidavit attached to our original motion, Your Honor. So we'll just stand on that.
Hold on a second, because I think I might be missing some things
Okay.
here. Look at the docket.
And Your Honor, I also note that this is a counterclaim file, so any order we would need to address the outstanding counterclaim as well. It's plaintiff's position, we would argue.
My system is moving slow. I can't pull up the file at the moment. We'll see if it comes up later. Let's come back to that one.
Yes, Your Honor.
Because I didn't think I had everything I needed in the file. I put a note. I didn't have everything I needed in the file to enter judgment on that one. All right, let's go to number 5. Phoebe Wasif.
Yes, Your Honor.
So I think that one's in position for default judgment.
It is, Your Honor, and we have since it was filed and the stay was issued, which is now going to be lifted. We have since received an affidavit, so I believe that you will want that to accompany with possibly a proposed order.
Yes.
So we will provide that to you to add to our motion for default judgment on that one, Your Honor.
All right.
And Your Honor, I didn't ask about the proposed order as far as the motions to lift stay. Do you want me to give you specific orders as regarding the stay that was issued on the one file for all these cases? Or are you satisfied with sounding the order on the one case?
I'm satisfied with the order on the one case, since it was never
Great.
separate order, never entered into separate dockets.
Yep, that's what I assumed you were going to say. I just wanted to be clear to make sure we were on the same page. Thank you.
All right. I finally was able to pull up the Lundstedt file. Yeah, that's what I'm missing. I'm missing the motion for summary judgment from this Lundstedt case.
The motion for summary judgment was e-filed with the court, Your Honor, on July 11th, 2019. I'd be happy to refile that for you.
If you
Uh,
would, because it is not, for whatever reasons, probably a fault on our end, we don't have it on our docket.
No problem. Your Honor, what I'll do is I'll file it along with the supplemental authority so that you have everything in our argument as well as the proposed order
All
and
right,
any of the exhibits, which include the affidavit.
all right, that will take care of that one. All right. Position 6, Ashley Jones. I think there was a motion for summary judgment. There's no response. So, motion for summary judgment is granted. I still think you're going to need some damages proof there.
Your Honor, I've also got that affidavit since it was put on hold. So I will also forward the court the affidavit and the proposed order for the motion for summary granting.
All right. And position 7 was a duplicate. Position 8, reset. Position 9 is settled. I think that concludes our business.
That's correct, Your Honor. Thank you so much. I may be excused.
You may be excused.
Take care.
All right. Let's take a break until 10:30, and then we'll deal with the Nicole Harris case.
Yes, sir.
Right. See, Mr. Farrell is back on. We have Ms. Harris on.
Yes.
All right, Harris and we have our court reporters.
We do not ask for a court reporter, Your Honor, just for the record.
All right, so Ms. Williams, I think you are
Yes, sir.
free to go on with your other duties.
Thank you so much. Have a great day.
Judge, do you want me to make a little preliminary statement?
So before you get there, Ms. Harris, you understand the nature of the proceedings that we're having today?
Yes.
All right. So this was an appeal from magistrate court judgment that was entered against you. And so I'm prepared to hear evidence relating to the damages sought by the plaintiff in this case. I understand that possession is no longer an issue, that Ms. Harris has vacated the premises.
Yes.
All right.
Yes, that's correct.
All right. So, all right, Mr. Farrell, you can go ahead.
Yeah, Your Honor, just as a preliminary matter, we received some documentation from Ms. Harris yesterday that she intends to introduce into evidence today. And we had anticipated that previously, so we had filed a motion in limine with respect to those, I'll call them certain defenses that she appears to be raising. And I'm going to kind of give the court a little bit of background, and then of course I'll let Ms. Harris respond, and then of course the court can decide it. I think that will determine how long the hearing lasts and the nature of the testimony given. So this case was filed, there was a demand for possession on or about September 28th, 2017. We filed our complaint on October 9th, 2017. The answer was filed on October 16th, 2017. And then there was a hearing on, let me back up for a second. On October 16th, there was an answer and a counterclaim filed. Then on October 31st, there was a hearing and the court has a judgment, but Ms. Harris at that time had basically withdrawn her counterclaim. And so the proceeding only was with respect to Invitation Homes's seeking possession damages for back owed rent. The day before the hearing on October 30th, Ms. Harris filed a complaint in Gwinnett County State Court seeking damage related to mold in the residence where she was living for Invitation Homes. And I've forwarded the court a copy of that complaint. Of course, we filed an answer. Then the court basically, because Ms. Harris did not submit discovery, basically there was a motion to strike, and then the court granted that. And then there was an amended motion. There was an amended order striking the complaint. That's also in the court's possession. And so the complaint that Ms. Harris filed really had to do with categorizing it as complaint relating to mold and water damage, either from a personal health point of view or from property damage. And our position is that case has already been resolved and it's not proper for Ms. Harris to introduce that evidence in this case.
All right, Ms. Harris, you want to respond to that? He's saying that you lost the opportunity to raise any issues about mold or personal injury because your other lawsuit was dismissed with prejudice.
Okay. Yes, sir. That was filed in the wrong jurisdiction. I was told I should have filed it in Fulton County, so that's when I did the what is it? Oh Lord. What am I trying to say? Hold on just 1 second. See, I'm sorry, I'm out of power, so I have no way of pulling up any of my documents or anything that's on my computer. That's why I'm hearing on the telephone call. But that's why I went and to file it in Fulton County. And so the reason I dismissed it, had it dismissed and did a appeal was because my attorney, I had to fire my attorney at that time. But what's going on is wrongful eviction because I wasn't, when they did the eviction, I moved out the property in June of 2017 due to water damages and mold. I had to live in a hotel, accumulated tons, spent out tons of money at this time. I don't understand why the eviction was even filed when I wasn't living there. I have phone recordings of them stating that they weren't going to fix anything else in the property. I had cameras in my home, video recordings of conversations of all this. And I have all this today, but like I stated, everything is on my computer and we have a power outage here.
But these issues were the subject of the complaint that you filed in Gwinnett County, is that right?
Right, and that was filed in the wrong jurisdiction.
Okay, but it wasn't, but the court didn't dismiss it for improper venue or lack of jurisdiction. They dismissed it on the merits because you wouldn't respond or prosecute the case or respond to discovery. Isn't that right?
Yeah, they said I was supposed to file it in the city that I lived in at Atlanta, so that's why I ended up filing it there.
Ms. Harris, who said that?
I was told by an attorney.
Okay, the court didn't say that.
No.
Okay. Well, Ms. Harris, these issues have been presented. And, once a court dismisses with prejudice, that means you've lost the opportunity to raise those issues. If you thought that, the court shouldn't have dismissed it, then really your remedy was to go back to that court and either ask for reconsideration or to appeal that order dismissing the complaint. But once the complaint's dismissed with prejudice, those claims are over, and I can't revisit those issues in this case.
Okay, that's fine, but it's what's here today really what's going on is the wrongful eviction.
Okay, but and again, we're not dealing with the eviction part of it. We're dealing with, because we know that you're out and that you've been out, but they're claiming that they're entitled to rent. And perhaps there are some other damages or costs that they intend to present, but I understand that, that one of the main claims is of unpaid rent. Do you understand that?
Right. I don't pay rent. My understanding is I had to leave because of what was going on in the property. I couldn't live there. It was hazardous, condemned. So why am I paying rent for somewhere that I had to leave? And I have a recording stating that they wasn't going to fix anything else.
But the issue with the hazardous condition is an issue that could have been raised, right, in the initial dispossessory. It wasn't, as far as I can see, because the counterclaim was voluntarily withdrawn. The issue with hazardous conditions was presented in Gwinnett County, but that was dismissed. So
Okay.
again, I'm having a hard time understanding how you can present that when those issues have already been essentially settled.
Okay. They told me they wasn't gonna fix anything else. If I wanted to, I could move and leave. And that's what I did in June. So why am I owing you rent if you're not gonna fix anything and I'm no longer living there?
Well, it hasn't been presented to me yet, but in this hearing, but I believe it's in the record that there's a lease, and the lease obligates you to pay rent, and under Georgia law, even if there's a failure to repair, you're still obligated to pay rent. You have some other remedies. You can assert a counterclaim and get a set off, but that ship has already sailed. Or you can repair and deduct, and that ship has sailed. So it appears to me from what you're telling me and from what I've seen in the lawsuit that you're still responsible for unpaid rent.
No, they told me I wasn't. That's what I'm explaining to you, sir. Why do I owe anything when you told me to leave because you wasn't going to pay anything and that I wouldn't be held liable for any monthly rent?
So you're saying that somebody from the landlord
Yes,
told you to
yes,
leave?
the president. Yes, the president.
Wait,
yes.
let me finish. They told you to leave and that you wouldn't be liable.
That's correct.
Okay, so who told you that?
The president of the company.
And what is the
That's why I was
president's name?
stating to you, sir, I have recordings and conversations.
All right, so and are you able to present that today?
I can't. That's what I'm explaining. That's what I called earlier this morning and spoke with Townsend and let him know that I have a power outage and I can't present anything. I can only call in, and he just told me to let you know what was going on.
Okay. Mr. Farrell, I think that's a valid issue that I at least need to hear, and give her opportunity to present that evidence.
Your Honor, I don't have an objection to if the court wants to reset the case, and also we are going to do a share screen, so it would be necessary for Ms. Harris to review the documents that we're presenting to the court and I guess present objections to those documents.
All right, so Ms. Harris, we're going to reset the case in light of your power outage, and so that you have a full opportunity to present your evidence and see and cross-examine plaintiff on their evidence. We're going to reset the hearing to a future date where you can have everything in front of you and we can have a full hearing on the merits of on that issue. So you'll hear from Mr. Townsend. We'll reset it, and hopefully within the next couple of weeks we can get this done, because I don't want this to linger out here too much longer.
Yes, sir.
All right. Mr. Rahimi, thank you for being here. I apologize for that we can't get this resolved today. Mr. Farrell, thank you for being here and being prepared. Unforeseen events, but we will get it resolved in the very near future.
Thank you, Your Honor.
Thank you, Judge.
All right, everybody have a good rest of the day.
You as well.
Thank you.
You as well. Bye.